The next lecture on our program deals with remedies in criminal law, and it will be given by Mr. Edward L. Greenspan. Mr. Greenspan was called to the bar in 1970 and is a partner in the law firm of Greenspan and Moldaver. He has been a lecturer at Osgoode Hall Law School in criminal procedure and a lecturer in criminal law at the University of Toronto Law School. He is editor-in-chief of Canadian Criminal Cases and of Martin's Criminal Code, and an assistant editor of the Dominion Law Reports and the Criminal Law Quarterly. Those of you who are fortunate enough to be here on March 5th, 1981, will be able today fully to appreciate a line that was used by Mr. Greenspan on December 23rd, 1980. And I thought I should give you this background. Mr. Greenspan, in December of 1980, defended on a charge of murder a gentleman arising out of the death of a young girl in the city of Toronto, and was successful in having his client discharged at the preliminary inquiry stage. And indeed, the judge commented on the lack of evidence against his client, as did Mr. Greenspan, who made a classic comment that all of you, I think, should remember always, and you'll see today really why those of us who know him knew and appreciated the remark that he made. As he walked from the courtroom, Mr. Greenspan is quoted to have said to the press, "I dream," said Mr. Greenspan, "I dream," said he, "of someday of being as thin as the evidence against my client in this case." Ladies and gentlemen, Mr. Edward Greenspan.
Thank you, Marvin. I was interested this morning in listening to Mr. Justice Estes' overview of remedies. He spoke of unjust enrichment, negligence, the Labor Relations Board, but he never directly discussed the criminal law. Well, once he mentioned the word sewers. That may have been an indirect reference to my field of specialty, but that was all. He never mentioned this subject. Another observation that he made that interested me was his reference to the last program on remedies in 1961. He observed that in the last 20 years, only 2 of those lecturers have died. Well, at his age, that may be a positive sign, but at my age, I don't like those odds at all. When I was invited to speak to you for 45 minutes on the subject of remedies in criminal matters, I thought I would only need a few moments because the remedies in criminal law are very simple. At the investigatory stage, the only remedy available for a possible target is prayer that an arrest won't occur. At the pretrial stage, there are 2 remedies for an accused person: prayer and flight. At the trial stage, the only remedy is a very good trial lawyer. And at the post-conviction stage, the remedies are escape and flight. For those accused people who stupidly elect to remain in this jurisdiction and stand trial, I dedicate the next 45 minutes to them. Now, the history of the criminal justice system is in large measure a history of remedies. The great advances in procedural safeguards for the accused are marked by such developments as the writ of habeas corpus and the supervision of inferior tribunals by the King's justices. And in comparatively recent times, the development of a court of appeal with comprehensive powers to correct errors in the lower courts. Consequently, it is difficult to truly appreciate the current state of the criminal law without an understanding of the historical basis of criminal law remedies. However, the restriction of time dictates that the focus of my remarks today be on the present state of the law, in an attempt to explore some problems or gaps in criminal justice remedies and to perhaps forecast certain developments. There are essentially 3 stages in the criminal trial process which deserve attention. Each contains its own problems, and each possesses its own set of remedies. Those stages may be categorized as the pretrial, the trial, and the appeal. For completeness, a 4th stage could be added, that of the prisoner. One might well suggest that at this final stage, all remedies have failed. Therefore, it is not surprising that this area is most vulnerable to administrative abuse. and probably most in need of remedy development. Allow me to return to the stages that I mentioned: pretrial, trial, and appeal. The critical feature in understanding remedies in criminal law is the fact of the appeal remedy. Since the enactment of the Criminal Code in 1892, and certainly since the extensive revisions in 1955, the fact of appeal has not only shaped the law of criminal remedies, but one might suggest it has in fact distorted that law. It is impossible to review the provisions of the Code, the decisions of appellate courts, and of the Supreme Court of Canada without concluding that the right of appeal afforded an accused is meant to be the exclusive remedy in the criminal justice system. This is not necessarily bad. There is considerable merit to a single route of review, and in the majority of criminal cases, the appeal system is not only the remedy required, but it is the only remedy required. However, the problem that I perceive is that in this headlong rush to appeal, important rights of citizens are becoming trampled. While I concede that there is a certain orderliness and efficiency in placing the remedy at the conclusion of the process following conviction, this tends to ignore the fact that some important rights are determined along the way to conviction or acquittal, rights which deserve protection and for which the appeal remedy is neither appropriate nor adequate. And I intend to focus on two illustrations of the problem, one in the pretrial stage and one in the trial stage. The first and most significant is the question of review of the preliminary hearing. As you are aware, in virtually every case where the accused will be tried in a court above the level of magistrate, he is entitled to a preliminary hearing. While that preliminary hearing has occasionally been characterized as an opportunity for the defense to obtain discovery of the Crown's case, its prime function, and indeed, according to the Supreme Court of Canada in the Patterson case, its only function is to determine whether there is sufficient evidence to place the accused on trial. And this is a critical stage of the criminal process. If an accused is discharged at the preliminary hearing, usually the matter has come to an end, and he need not go through the harrowing experience of a trial. On the other hand, should he be committed for trial, then his problems are only beginning. There is no appeal from the decision of a magistrate on a preliminary hearing. The historic review of these proceedings was by way of the prerogative remedies, the writs of certiorari or prohibition, depending on the stage of the preliminary at which review was sought, or by way of habeas corpus with certiorari in aid if the accused is in custody. These writs are only briefly referred to in Part 23 of the Criminal Code, and at the preliminary hearing stage, it is primarily the common law which governs their application. As there is no statutory appeal, one would hopefully anticipate the full scope of these writs would operate and permit a wide review of the magistrate's conduct of the proceedings and his decision on committal. That is not so. And I suggest the reason is obvious, although perhaps not justifiable. Recently, the preliminary hearing has been viewed merely as a step on the road to conviction, at which time the appeal right arises. Reviewing the preliminary hearing is clearly most unsatisfactory from an efficiency standpoint, and as a result, the grounds upon which review by way of prerogative writ may be undertaken have been narrowed to one ground: jurisdictional error. And I think it is important to appreciate that this result was not inevitable. There is no privative clause relating to preliminary hearing proceedings which dictated such a course, and no appeal route which offered an alternative review. The irony is that the case which formed the basis for many of the decisions which have culminated in the restriction of grounds of review to jurisdiction is a decision of the Judicial Committee of the Privy Council in the King and Nat Bell, not with respect to a preliminary hearing, but rather a summary conviction offense under a provincial statute, the Alberta Liquor Act. The judgment of Lord Sumner is at best a questionable piece of legal reasoning. He says, "It has been said that the matter may be regarded as a question of jurisdiction, and that a justice who convicts without evidence is acting without jurisdiction to do so. Accordingly, want of essential evidence is ascertained somehow, if ascertained somehow, is on the same footing as want of qualification in the magistrate, and goes to the question of his right to enter on the case at all. Want of evidence on which to convict is the same as want of jurisdiction to take evidence at all. This clearly is erroneous. A justice who convicts without evidence is doing something that he ought not to do, but he is doing it as a judge. And if his jurisdiction to entertain the charge is not open to impeachment, his subsequent error, however grave, is a wrong exercise of a jurisdiction which he has, and not a usurpation of a jurisdiction which he has not." Now, time here doesn't permit a detailed analysis of the legitimacy of this kind of reasoning. In any event, at this time, 60 years after the judgment, it really is not of great moment. What is important is this, that once courts determined to limit review to jurisdictional grounds and then relied on this type of logic, the scope for attack by way of prerogative writ narrowed. While the grounds for review by way of prerogative writ have greatly expanded in other areas, particularly in this area of criminal law, the prerogative writ, the only remedy available to an accused, has been virtually sterilized. Thus, while in other areas of the law, error of law on the face of the record and jurisdictional error were the two important grounds for review of the decision of a tribunal required to act judicially, as a magistrate presiding at a preliminary hearing is required to do, error of law has been totally eliminated. Thus, in the case of Martin, Simard, and Desjardins and the Queen, Mr. Justice Morden, then of the High Court, in a lengthy and learned judgment, wrote that in criminal as in civil proceedings, quote, "the two basic grounds for certiorari are jurisdictional error and error of law on the face of the record, and these are quite separate and unrelated grounds." His Lordship further held that either ground is a basis for attack of a preliminary hearing, and most importantly, that absence of evidence on a material element gives rise to an error of law. In the result, His Lordship quashed the committals for trial of Martin and the committal for trial of Desjardins on 2 of 3 counts and of Simard on 1 of 3 counts for a total lack of evidence. This decision was reversed on appeal, but it is interesting to note that Martin, who stood accused in the dredging conspiracy trial, which lasted over 14 months, was acquitted. 14 months of his life that Mr. Justice Morden said were unwarranted in law. Now let's go back to the decision of the Court of Appeal on the certiorari application. They referred to Nat Bell, and subsequent authority held that a committal for trial could only be quashed on jurisdictional grounds, and in the context of the sufficiency of evidence, the Court of Appeal said this, that meant that the learned provincial court judge here acted within his jurisdiction, unless it can be said that he committed these respondents on the count specified without any evidence at all, in the sense of an entire absence of proper material as a basis for the formation of a judicial opinion that the evidence was sufficient to put the accused on trial. That is quite a different question from the question whether in the opinion of the reviewing tribunal there was evidence upon which a properly instructed jury acting judicially could convict. The learned provincial court judge, having properly directed his mind to the evidence and to the question of whether there was sufficient evidence to commit, his decision is not subject to review. As I have said, there was no necessity whatsoever for such a restricted view. But I suggest that there is an important indication to the reasoning of the court when citing with approval the following passage from the Alberta Court of Appeal decision in Regina and DePadgie. And that quote is as follows. "The case at bar points up the intolerable delays that result in the administration of justice if the Supreme Court, by use of certiorari or mandamus, undertakes to supervise the cross-examination of witnesses in a preliminary hearing. Here, 2 years and some months after the accused was arrested, the preliminary has not yet been completed. Delay. At all costs, avoid delay. For the Alberta Court of Appeal, the remedy for delay is to emasculate the remedy. Similar reasoning is found in the very important Supreme Court of Canada case of Attorney General for Quebec versus Cohen, where the court, in making it clear that erroneous rulings as to the admissibility of evidence at a preliminary hearing cannot be attacked by way of certiorari, stated as follows: in dealing with certiorari, one must never forget that it is a discretionary remedy. In the exercise of this discretion with reference to proceedings at a preliminary inquiry, it is essential to bear in mind that in the interest of the effective administration of criminal justice, it is of paramount importance to avoid unnecessary delays, especially delays in bringing the case to trial. If certiorari is issued at the stage of preliminary inquiry, there is a possibility of an appeal, and how long this may delay the trial is obvious. The application for certiorari in the present case is dated February the 10th, 1975, and the decision of the Supreme Court of Canada was delivered in 1979. It is clear that the emphasis has shifted towards an efficient criminal justice system. But in striving for speed, have the courts closed their eyes to justice? In my view, there is a need for review of preliminary hearing committals as a matter of fairness and fundamental justice. And I will illustrate the point with two cases which demonstrate the inequities where such a power of review is lacking, and show that the gods of efficiency have given us a remedy to a problem that is much worse than the problem of the remedy. Section 586 of the Criminal Code says, "No person shall be convicted of an offense upon the unsworn evidence of a child, unless the evidence of the child is corroborated in a material particular by evidence that implicates the accused." Legislative concern that an accused person not be convicted on the unsworn, uncorroborated evidence of a child is so strong that a similar prohibition is also found in Section 16 of the Canada Evidence Act. One would have thought that because no person can be convicted on the unsworn, uncorroborated evidence of a child, that one could not be committed to stand trial where the sole evidence against the accused was unsworn and uncorroborated. One could reasonably suggest that it is both unfair and inefficient to put a person on trial where the only evidence against him cannot sustain a conviction. Nevertheless, in Re Catzman the Queen, an attempt was made to quash a decision of a magistrate who had committed an accused to stand trial in exactly those circumstances. The application for certiorari was dismissed, the justice being of the view that the magistrate was entitled to consider that the complainant might be sworn at trial, and in which case her evidence would be sufficient, if believed, to sustain a conviction. One could almost conclude from the judgment that the Superior Court hearing that certiorari application was of the view that the magistrate had not erred in committing the accused for trial. A different view was taken in the subsequent case of Regina versus Stillo. Again, an application for certiorari to quash an order for committal in a case of indecent assault when the only evidence at the preliminary hearing was the unsworn evidence of a child. Mr. Justice Corey acknowledged that the unsworn evidence of a child possessed no probative value whatsoever unless it was corroborated, and that the magistrate had erred in committing the accused to stand trial. He felt himself bound, however, by the straitjacket imposed by the Supreme Court of Canada in Re Martin, Simard, and Desjardins. His Lordship clearly articulated the very limited role to which the writ of certiorari has been relegated. My role on a certiorari application is very strictly limited. What I must do is to determine whether the committal was made arbitrarily, or at the most, whether there was some evidence upon which an opinion could be formed that the accused should go to trial. And the result, the committal for trial was upheld although there was no evidence of the offense. Whatever one view takes as to the correctness of these two decisions, the words of Mr. Justice Corey in the Stillo case focus on the possible injustice which has resulted from the lack of an adequate remedy. As he said, to commit an accused for trial is a very serious step. The charge pertaining to the indecent assault of a child carries with it drastic consequences for an accused in the community. It seems to me that it is unfair to put the accused through his trial if there is no corroboration of the unsworn testimony of the child at the time of the preliminary hearing. Parents are aroused by cases of this sort, for the damage that may be done to children can be irreparable. To put the accused through a trial where corroborative evidence is not available at the time of the preliminary is to bring down upon him the opprobrium and scorn of the community, even though at the time of trial he is bound to be acquitted. He would be castigated by his peers for an offense for which he could not be convicted. In my submission, it is apparent that lack of an adequate remedy can lead to serious abuse and injustice at the preliminary hearing stage. But I do detect a trend, not very strong perhaps, but a trend towards a more flexible approach to the role of the prerogative remedy at the preliminary hearing stage. The history of writs in this area has always been marked by a widening, then a narrowing of their availability. And two recent decisions of the Supreme Court of Canada give hope for a more liberal approach. The first decision in time is that of Forsyth and the Queen. The facts there essentially concern the proper procedure when seeking to question a rape complainant as to her prior sexual conduct with persons other than the accused. The court dealt at length with the proper interpretation to be placed on Section 142 of the Criminal Code, and it was only incidental that these important issues arose, in fact, at a preliminary hearing. However, Chief Justice Laskin, speaking for the court, reviewed the scope of certiorari, and while dismissing this particular application, said as follows: that certiorari may be invoked to quash a committal for trial is accepted law in Canada. The fact that it is a discretionary remedy and may be refused where there is another recourse does not affect resort to it in respect of a committal for trial, since there is no other recourse. Committals for trial are not appealable and can only be challenged by certiorari or motion to quash. What then are the grounds upon which a successful challenge may be made? In Patterson, this court stated that lack of jurisdiction was the only ground for quashing a committal for trial. The decision was based upon a particular fact situation. In speaking of lack of jurisdiction, this court was not referring to lack of initial jurisdiction of a judge or a magistrate to enter upon a preliminary inquiry. This is hardly a likelihood. The concern rather was with the loss of this initial jurisdiction, and in my opinion, the situations in which there can be a loss of jurisdiction in the course of a preliminary inquiry are few indeed. However, jurisdiction will be lost by a magistrate who fails to observe a mandatory provision of the Criminal Code. Canadian law recognizes that a denial of natural justice goes to jurisdiction. In the case of a preliminary inquiry, I cannot conceive that this could arise other than by a complete denial of the accused of a right to call witnesses or a right to cross-examine prosecution witnesses. Mere disallowance of a question or questions in cross-examination or other rulings on proffered evidence would not amount to jurisdictional error. However, the judge or magistrate who presides at a preliminary inquiry has the obligation to obey the jurisdictional prescriptions of Section 475 of the Criminal Code. Although this analysis is somewhat encouraging, even more encouraging is the very recent judgment of the Supreme Court of Canada and Chabot and the Queen. Chabot had been charged with second-degree murder, but at the conclusion of the preliminary hearing, the magistrate committed him for trial on a charge of first-degree murder. The case involved a clear jurisdictional issue. Did the magistrate have jurisdiction to commit the accused for a more serious charge than the one upon which the preliminary hearing was held? Ultimately, the Supreme Court of Canada held that he did not, and they quashed the committal. But this, however, was not the most critical determination. A preliminary issue arose as to when certiorari was available. In Chabot's case, the Crown had immediately following the committal for trial drawn and filed an indictment. Prior to Chabot, there was authority to the effect that once the indictment had been filed with the court, the indictment was the foundation for any further proceedings, and an attack on the committal for trial by way of certiorari was no longer available. As the criminal code was silent as to the proper practice, it was essentially a question of policy for the Supreme Court of Canada. If the mere filing of an indictment precluded any attack on the preliminary hearing, then as a practical matter, there would no longer be any remedy to review a committal for trial. The court, however, took a stand against that position and held that only where the indictment is before a court constituted to actually try the accused can he no longer attack the committal for trial. Mr. Justice Dixon said, for the court, if the simple act of filing were to be determinative, the accused would be left in the position where his right to move to quash his committal for trial due to irregularities in the preliminary inquiry would depend upon the decision of the prosecutor as to the appropriate moment for filing the indictment. The right to challenge committal for trial by prerogative writ would be fleeting indeed. Witness the present case. In the language of Mr. Justice Creever in Jolly, the race would be to the swifter. The accused remedy should not be left to the whim of the Crown. I can see little justification for raising technical obstructions to the right of an accused to attack by prerogative writ his committal for trial, down to the time when he may be called upon to answer the indictment. Now, this position, in my view, is a clear departure from earlier decisions which focused on expediency and efficiency. Hopefully, it's the precursor of a more flexible approach in the area. And if I can look for a minute at the trial remedies. Both statutory and judge-made law make it clear that except in the most exceptional cases, the prerogative writs are never available to review decisions made at the trial. Parliament, enacting the privative clause of Section 710 of the Criminal Code, has effectively barred resort to certiorari to quash a conviction, even on jurisdictional grounds. And a series of decisions of the High Court and Court of Appeal have left little doubt that prerogative remedies may not be advanced to review decisions made during the trial. Mr. Justice Henry in the Madden case said this: the occasions upon which the Superior Court will intervene by way of prerogative remedies in the course of a trial will be rare indeed. Short of conducting himself in a manner that shocks the judicial conscience, a trial judge who has embarked upon a trial over which he has jurisdiction should be left free to complete it, and challenges to decisions made by him in the course of the trial should be initiated through the ordinary appeal procedure, not by way of the extraordinary remedies. The latter should be available only for extraordinary cases. While these must be determined as they arise, it is obvious that their effect, whether initiated by the Crown or the accused, frustrates the orderly progress of the trial, renders uncertain the expectation of its completion, and creates a climate that is not conducive to a fair trial and the due administration of justice. As a result of these kinds of cases, the impact of the appeal remedy is almost total with respect to prerogative writs. And during or immediately prior to trial, there are very few other remedies which escape this pressure. An illustration of the problem is the concept of a trial court's inherent power to stay proceedings as an abusive process. This remedy, which is relatively well developed in civil law, has been seriously undermined in the area of criminal law. It would not be fair to place the blame wholly on the fact that there exists a wide appeal remedy, but the appeal fact has again tended to distort the issues involved. Where a wide appeal power exists, there is a tendency to believe that all wrongs and injustices will eventually be resolved through the appeal route. There are, however, gaps in the statutory scheme of appeal, and one important gap which I perceive is the lack of power in the appellate court to protect an accused from real oppression by the Crown and law enforcement. So long as the perceived oppression was accomplished according to law, the appeal remedy will not be adequate. The law with respect to abusive process has been on a roller coaster since the decision of the House of Lords and Connolly in the DPP and the decision of the Supreme Court of Canada in Regina versus Osborne. Since those judgments, there have been a multitude of cases in inferior courts in which a common theme is a judicial reluctance to accept superior court pronouncements that the remedy of stay of proceedings does not exist. Mr. Justice Pigeon and Osborne said this: "It is basic in our jurisprudence that the duty of the courts is to apply the law as it exists, not to enforce it or not in their discretion. As a general rule, legal remedies are available in an absolute way ex debito justitiae. Some are discretionary, but this does not destroy the general rule. I can see no legal basis for holding that criminal remedies are subject to the rule that they are to be refused whenever, in its discretion, a court considers the prosecution oppressive." This analysis has been subjected to extensive scrutiny to detect a gap in this apparent wall against the existence of the remedy. In the later case of Rourke, Mr. Justice Pigeon, speaking for the majority of the court, spoke in what can be considered even more explicit terms. "For the reasons I gave in Osborne, I cannot admit of any general discretionary power in courts of criminal jurisdiction to stay proceedings regularly instituted, because the prosecution is considered oppressive. In fact, I think the correct view is that which was expressed by Viscount Dilhorn in the DPP and Humphreys." And he quotes from that a portion: "A judge must keep out of the arena. He should not have or appear to have any responsibility for the institution of a prosecution. The functions of a prosecutor and of judges must not be blurred. If a judge has power to decline to hear a case because he does not think it should be brought, then it soon may be thought that the cases he allows to proceed are cases brought with his consent or approval. If there is the power which my noble and learned friends think there is to stop a prosecution on indictment in limine, it is in my clear view a power that should only be exercised in the most exceptional circumstances." In succeeding cases, the words of Mr. Justice Pigeon and Viscount Dilhorn have been subjected to very careful scrutiny and analysis, as if in fact they were the words of a statute. Interestingly enough, it was the lack of an appeal remedy in cases where proceedings are stayed as an abusive process which influenced the decision. Mr. Justice Pigeon concluded his judgment as follows: "In my view, the absence of any provision in the criminal code contemplating the staying of an indictment by a trial judge or an appeal from such decision is a strong indication against the existence of any power to grant such a stay. The present legislative policy is clearly in the direction of allowing a right of appeal from final trial court judgments on indictable offenses in all cases. Section 9 of the Criminal Code gives a right of appeal against conviction for contempt of court, and this was extended in 1972 to a conviction for contempt in the face of the court. Section 719(5), enacted in 1965, gives a right of appeal in habeas corpus matters. It would hardly be consistent with such policy to have a discretionary jurisdiction that could be exercised by superior court judges in criminal matters where the only possible appeal would be a direct appeal to this court under the Supreme Court Act. Considerations of policy may not be of much importance in the application of explicit statutory provisions because policy decisions are essentially for Parliament. It is quite another matter when we are dealing with unwritten principles. In broad terms, it is probably correct to assert that stay of proceedings as a remedy in the trial court is extremely limited and exists only in the most exceptional circumstances. Nevertheless, even in this area, I see hopeful signs and positive indication that the remedy still exists. I suggest that the possibility of real abuse without such a remedy is so likely that the courts will be reluctant to leave an accused without a remedy. The possibility was starkly exposed in a decision by Mr. Justice Creever styled Regina versus Cernick, Bradley, and Shelley. In that case, one of the accused, Bradley, agreed to provide the police with a formal statement on the express condition from Crown Counsel having conduct of the case that the statement would never be used against her. And further, if the statement was consistent with the known facts, the charges against Bradley would be stayed, and she would be called solely as a witness against the co-accused. After Bradley gave the statement, the Crown Attorney indicated to her that he would not be proceeding against her and would only require her as a witness against Cernick at his trial on the charge of murder. Further, the Crown also undertook not to proceed against the third co-accused, Shelley. And Bradley and Shelley were very happy people. Subsequently, a different Crown Attorney assumed carriage of the case, and he decided that it was not in the interests of the Crown that Bradley and Shelley not be prosecuted. A decision was then made to prosecute all three. At trial, both Bradley and Shelley, crying, applied to stay the proceedings as an abuse of the court's process. The application with respect to Bradley's was granted. Shelley's wasn't. Mr. Justice Creever was of the view that not only did a superior court of criminal jurisdiction have power to stay proceedings as a result of an abuse of process, but that the case in question was a very clear example of such an abuse. Certainly the conduct of the Crown in reneging on its agreement with Bradley for her cooperation undermined the administration of justice. Further, the Crown's withdrawal from the agreement seriously prejudiced Bradley's defense. Were she to testify, the Crown was entitled to cross-examine her on her prior agreement with the Crown. Shelley, however, was simply a gratuitous beneficiary of the original agreement between the Crown and Bradley and would not be prejudiced by the Crown's change of mind. Now, there have been other cases since Rourke, both for and against the existence of the power. And I'm going to make just a brief reference to three of them, which demonstrate, in my view, a trend by appellate courts towards a recognition of the power. In Re Abitibi Paper Company Limited and the Queen, the corporate accused operated a paper mill and entered into discussions with a senior official of the Ontario Ministry of the Environment as to the development of a program to eliminate pollution caused by one of the accused paper mills. The program was ultimately approved by the minister, but in order to avoid delay, the accused cleanup program was instituted without obtaining the official approval of the director. Under the provisions of the Environmental Protection Act, approval of a program by the director provides the accused with immunity from prosecution under the Act while the work proceeds. However, shortly after the ministry official had met with the accused engineer and expressed satisfaction with the progress of the program, charges were laid under the Act. At trial, the provincial court judge stayed the proceedings as an abusive process, as the accused had done exactly what was promised on the assumption that the Ministry of the Environment would fulfill its undertaking not to prosecute. The Crown's application to the Divisional Court for an order directing the trial judge to proceed with the trial was granted. But on appeal to the Court of Appeal, the Divisional Court order was set aside. Mr. Justice Arnott, with whom Madam Justice Wilson concurred, although not commenting on the power of a court to stay proceedings in a criminal law situation, held that the power to prevent an abusive process in civil proceedings had always existed and remains unimpaired by Rourke. Mr. Justice Jessup, the third member of the court, went on to apply in obiter the same rationale to courts of criminal jurisdiction. He said, "I conclude, therefore, although not without hesitation, that abusive process has a place in criminal jurisdiction of our courts, but that its application is limited to cases of the most exceptional circumstances. And the cases use such adjectives as vexatious, unfair, oppressive, and now most exceptional circumstances in describing conduct deemed to be an abusive process. In my opinion, the conduct of the Crown in this case in breach of an undertaking by one of its senior officers attracts each of the adjectives I have mentioned." There have been two Supreme Court of Canada cases, Kersner, which preceded Abitibi, and Cranenberg. The members of the court spoke in terms which I submit lend credence to the position that the remedy is very much alive in Canada. Chief Justice Laskin, in his concurring opinion in Kersner, said this: "Having indicated that I preferred to leave open the question whether entrapment, if established, should operate as a defense, I expressed no view on the approach taken in a case where it was discussed. Similarly, I leave open the question whether the appropriate way to deal with entrapment is by way of stay of proceedings, a matter considered by this court in another context in Rourke." In Cranenberg, Mr. Justice Dixon said this: "The appellate division was of opinion that the court had lost jurisdiction over the offense, but that a new information was available, if one could be laid within the limitation period for summary conviction cases. The question of whether a new information may be laid after jurisdiction has been lost is not before us, and I refrain from any extended discussion on the point, in the absence of argument and on the narrow facts of this case. It is manifest, however, that there will be occasions on which the laying of a new information will not be available. Time limitations may preclude it. Indeed, the laying of another information may amount to nothing less than an abuse of process. The successful challenge to jurisdiction may not come until after the trial on the merits and conviction. The full effect of Section 440.12 of the Code and possible prejudice to the accused through the laying of a new information would require consideration." Now, clearly based on these comments, I believe that I am well within my right to suggest that it is fair to assert that the remedy of stay of proceedings has not died, and to further predict that it will eventually come to assume a role as an important remedy against Crown abuse and oppression. Finally, I want to address briefly the category of prisoner remedies. This is an area of the criminal justice system which is open to grave abuse and injustice. Perhaps not surprisingly, there is a reluctance in recognizing rights for prisoners who have exhausted their appeal rights and should be settling down to serve their sentences. While the Code contains an elaborate appeal structure, it is essentially silent on this aspect of the criminal justice system, except in the negative sense. Section 716 provides, "No warrant of committal shall, on certiorari or habeas corpus, be held to be void by reason only of any defect therein, where A, it is alleged in the warrant that the defendant was convicted, and B, there is a valid conviction to sustain the warrant." A discussion of prisoners and remedies must include reference to the rather awesome powers of the National Parole Board. The judgments of the Supreme Court of Canada illustrate that serious abuse and injustice can result from lack of an effective remedy. A chilling example is the case of Mitchell. In that case, Mitchell was released on parole with his term of imprisonment set to expire on January the 1st, 1974. On December 23rd, 1973, after 2 years on parole, and just 8 days before the end of his sentence, Mitchell was arrested without reason or explanation and returned to custody. Ultimately, his parole was revoked without reasons, and he was required to serve once again the 2 years which he had already served on parole. His application for habeas corpus was unsuccessful. But Chief Justice Laskin, in a dissenting decision, began his judgment as follows: "The uncontested facts on which the application is based tend to shock from the mere narration. The plain fact is that the National Parole Board claims a tyrannical authority that I believe is without precedent among administrative agencies in power to deal with a person's liberties. It claims an unfettered power to deal with an inmate almost as if he were a mere puppet on a string. What standards the statute indicates are on the board's contentions for it to apply according to its appreciation and without accountability to the courts. Its words must be taken that it is acting fairly without it being obliged to give the slightest indication of why it was moved to suspend or revoke parole." Now, I should note that since that Mitchell case, Parliament has in fact amended the Parole Act to provide that time spent out of custody on parole counts against the sentence, and also to provide for a post-revocation hearing where the prisoner may make representations. In my view, Mitchell remains a prime example, though, of the serious injustice which results from lack of adequate remedies. However, even in this area, there are indications that the courts are prepared to recognize remedies as an extension of the duty of fairness which the Supreme Court of Canada considered in the ReNicholson case. That judgment has not only had an important impact on administrative law, but it has been applied in the post-appeal stage and breathed new life into the writ of certiorari in the criminal justice context. In a case called Martineau and the Matsqui Institution Disciplinary Board No. 2, the court held that the common law remedy of certiorari was available in the Federal Court Trial Division to enforce the duty of fairness imposed on an administrative tribunal such as an inmate disciplinary board having the power to punish through loss of privilege. Mr. Justice Pigeon, in the majority decision, while placing limits on the remedy, clearly recognized its importance. In his concurring opinion, Mr. Justice Dixon explored in detail the scope of the duty of fairness and its enforcement through the courts. He was of the view that any public body, other than those making purely ministerial or legislative decisions, is under a duty to act fairly when dealing with persons' rights, and he was prepared to give a wide interpretation as to the meaning of rights. He said this: "When concerned with individual cases and aggrieved persons, there is the tendency to forget that one is dealing with public law remedies which, when granted by the courts, not only set a right individual in justice, but also ensure that public bodies exercising powers affecting citizens heed the jurisdiction granted them. Certiorari stems from the assumption by the courts of supervisory powers over certain tribunals in order to assure the proper functioning of the machinery of government. To give a narrow or technical interpretation to rights in an individual sense is to misconceive the broader purpose of judicial review of administrative action. One should, I suggest, begin with the premise that any public body exercising power over subjects may be amenable to judicial supervision, the individual interest involved being but one factor to be considered in resolving the broad policy question of the nature of review appropriate for the particular administrative body. The importance of this decision cannot be overemphasized. Many of the decisions made with respect to prisoners and others in the post-appeal stage could fall within this dicta and thus lead to a requirement of procedural fairness, which can be enforced through the courts. Thus, recently in Abel versus the Advisory Review Board, the Ontario Court of Appeal held that the Advisory Review Board was under a duty to act fairly with the patients who came before it for review of their detention on Lieutenant Governor's warrants, following findings of not guilty by reason of insanity and unfitness to stand trial. The board was required to decide whether in a particular case the patient could have access to the materials submitted to the board by the staff of the psychiatric facility. The board's recommendation to the Lieutenant Governor affected the patient's rights, and the duty of fairness could be enforced through certiorari. And in the most encouraging development in this area, the duty of fairness was imposed on the National Parole Board on parole revocation hearings. In Re Dubo and the National Parole Board, Mr. Justice Smith of the Federal Court Trial Division quashed a parole revocation where, without prior notice, the parolee was questioned as to his outstanding criminal charges and denied counsel. His Lordship concluded his judgment as follows: "I am mindful also of the fact that the primary purpose of certiorari is to see that minor tribunals conduct their hearings correctly and fairly. This purpose has been stated to be even more important than that of protecting individual rights." Lest it be thought that this is an isolated development, Mr. Justice Collier reached a similar conclusion in the later case of Calvin versus the National Parole Board. As I said earlier, this area is one which, more than any other, is in the developmental stage, and where further steps can still take place in safeguarding persons from abuse. I have only had the opportunity in these remarks to scratch the surface of criminal remedies, and while I am firmly of the view that there are serious gaps in remedies available to accused persons both before and after trial, I also perceive reason for optimism in the continued expansion of the court's willingness to intervene in order to remedy serious cases of injustice. Thank you.